Hi everyone, welcome to the immigration, Q&A live we're doing, JQK Law Firm. I'm John Khosravi. Thank you for joining us every 5 p.m. Pacific time. 5 p.m. Pacific. We've been doing it for almost more than a year now since the pandemic started. So keeping it going, don't want to miss any of them. So we've been pretty consistent on that. Thank you everyone for joining. We're going to take your questions as they're coming. We have a lot of questions. Actually, I forgot to start the TikTok feed. I'll do that as we're talking right now. But I want to let everyone know that you're here on YouTube, on Facebook, and in a second on TikTok and on LinkedIn, where we take your general questions about U.S. immigration. You can't give specific guidance because things are different for every case. But I try to answer everything I can and give you my thoughts and what issues exist that are on my mind on this kind of stuff, because U.S. immigration gets pretty complicated. They change the rules a lot. Some stuff doesn't even have any rules, so we kind of are just stuck there to do the best we can based on maybe prior experiences, maybe based on what we've seen before, and a lot of study. So we'll do our best to just give you some guidance and ideas of what's going on in U.S. immigration. What fun thing we do is we have a free raffle we give away, 3 of them actually per episode right now. And the live program, if you're watching it, every 10 minutes or so, my assistant will name off someone who liked, subscribed, and said consultation, and we'll give a free video consultation, a 15-minute video consultation for those people, so they could get involved and ask any questions they have on a live setting. So with that, let's get it started. What a week it's been. It keeps getting crazier and crazier with this administration and some stuff. It's not even the administration itself. It's just the fact that things are going nuts with the immigration world. I mean, the embassies right now, the backlog is going to be pushing past 600,000 cases for those who are waiting for immigrant visas. Those are green cards. And immigrant visa appointments are not really being scheduled in most places of the world. And so we're waiting on them to start, processing things. USCIS, the internal system, is working. Those are going through. And so where we're keeping those going. I just want to say hi to 29 Super C and Claudia Stewart. Thank you so much. You guys are regulars. Thanks for coming in and talking. It's a pleasure talking with you as always. But immigration is happening. Some citizenship cases are happening really fast. So if you file for naturalization for N400, I have cases, and I've seen colleagues' cases, having interviewed 2 to 3 months after submission, which is crazy. But on the other end, some cases take longer. One of the main things that's popped up that's really troublesome is regarding biometrics appointments. So what happened is that for certain types of cases, when you file in the United States, like adjustment of status, like most change of status or extension of status cases, you have to do your fingerprints. It's biometrics, to take a photo and your fingerprints. Because of COVID, they have shut down a lot of these locations, and now that they're opening up, they're only slowly opening up. So there's a huge backlog. There are people who haven't got their biometrics appointments in like 10 months. So it's very frustrating. I have a client for a re-entry permit, took over a year to get their biometrics notice. Now traditionally, if you miss one of your biometrics appointments, they would automatically reschedule without a problem. The notice for biometrics states on it that it used to state on it up until last month that if you can't make it, just mail the notice to a location, mark a box on that receipt notice, and you'll be okay. It's always been fine. But they changed it up where they closed down the service center that was taking care of that situation, and they say you have to call the 1-800 number for USCIS. Now this is really troublesome because the 1-800 number, getting a hold of a person is almost impossible, especially if you're not a lawyer, and sometimes they're going to be on hold for over an hour. And it's not guaranteed that they'll accept the rescheduling. So something pops, you get the notice, something pops up on that day, you can't go. You call the 1-800 number, they'll say, well, we'll think about it, let you know in 30 days. Well, the appointment's coming up in much less time than that. So it creates a lot of troubles. If someone misses it, potentially they'll say they just denied the case, which is really harsh. Even Trump didn't go that crazy with it. So it's just annoying that they're doing this with the biometrics, but we'll have to wait to see what happens. Hopefully it gets fixed up. Hey, I'm an initial DACA applicant. How long could the Biden administration take to appeal the ruling? When it comes to federal court cases, and I have another question I guess Notorious asked again, there are no timetables with regards to federal litigation. Sometimes these cases take months and years, back and forth, they get pushed back. So there's no answer to the question of how long it takes. We don't know. It's just one of those things that we just wait and hopefully have it faster, but most of it is out of our control. The national visa center backlog last year was approximately 532,000. Yeah, I mean, that's what the published numbers were, 532,000, but it's probably going to be nearing 600,000 since that time. And my YouTube channel should be working. We have two YouTube channels. One's JQK Law Firm, and one is JQK Clips. And that's you know, clips of the stuff we talk about, we put on that channel, so you can take a look and see what's going on there. But it's tough. Claudius follows up saying, I'm very rough indeed on these backlogs. It's tough. I mean, I haven't read the article yet, but Reason Magazine or Reason.com did an article about why these backlogs are happening. And I just read the title. I haven't had around to read the actual thing, but it kind of insinuated that the embassy officers were returned. A lot of them came back to the United States when the pandemic happened to be, you know, out of these danger zones and be back with their family, and they're just not back yet. And I think they're leaving up to them if they want to go back. What they're giving a lot of attention on that kind of stuff. So if that's the case, it's kind of hard, and I understand, you know, if consular officers got to do what they got to do, but there's a lot of families separated. There are a lot of people whose dreams are being destroyed right before our eyes. So hopefully, if you get it back and going, it's a wild situation that we're seeing. Rana asked, a U1 visa applicant, a U visa applicant, was single when filed, and after that got proven. And meanwhile, while waiting, I'm guessing you're going to say they got married. Can they apply for the spouse and kids for the dependents? I don't handle U visas anymore, but there's some stringent requirements on the timing of the marriage that happens. So you definitely need to talk with an immigration attorney so you could go through this process and break it down. I don't handle these kind of cases, but the timing of when you get married does have an effect on U visas. It's a little bit different, but it's just not a case I handle, so I don't have offhand quick knowledge that I could just impart on this particular situation. Is it possible to receive a 10-year green card if married less than 2 years? I received 10-year green card. So this is a really important issue that pops up. The basis of it is, if you get married and file for a green card and the green card issue date is within 2 years of your marriage, so you have your second marriage anniversary, get your green card before that, you're supposed to only get a 2-year green card. Not a 10-year green card. And the reason is based on a ridiculous law they passed in the early 90s because they mistakenly thought there was a lot of marriage fraud, which there wasn't, and it's proven to be the case. You have to file another application to get a 10-year green card, and that application is about proving that the relationship was real and it was not fake. I'm going to do a lot of work on this in the future. We've seen a lot of videos about this topic. I'm going to be challenging how ridiculous this rule is. But one issue that happens is sometimes USCIS will issue a 10-year green card when they're supposed to issue a 2-year green card. And so a lot of people are like, oh, that's good, it saves me the trouble of doing it again, their error. But nope, even if it's their error, it's your error. So if you mistakenly received a 10-year green card instead of a 2-year, you should notify USCIS to get the correct one, and you should file the removal of conditions form I-751 even if you're mistakenly given a 10-year green card when you were supposed to get a 2-year green card. So if you don't, you're going to be potentially sent to immigration court for removal because you didn't properly file removal conditions in time. You want to avoid that headache. It's possible to fix it all. That's a lot of time, money, and stress that I don't want you to go through. So if you have this kind of situation, definitely be on top of it. Don't just think it's a lucky break. It's not. But one thing to note is the issue date of a green card, if you did consular processing, is the day that you enter the airport, the first day you enter the airport after getting your immigrant visa. So if you're getting a green card when the foreign spouse is overseas, they go to the embassy, they do an interview, and then they fly into the United States after they got their visa, and the date of entry is it. Now sometimes, by the time, especially with the delays we have right now, sometimes by the time you have your interview and by the time you come to the United States, it's near 2 years after the wedding anniversary anyway. So in those cases, I had clients where I told them, listen, you got your visa, your second wedding anniversary is in a month, don't enter the United States until a day after your wedding anniversary. So when you do enter, you automatically and correctly will get the 10-year green card. So that's a really important thing to think about, because getting the 2-year green card is a very obnoxious and costly thing to have to deal with. So that's the last thing. If we get away with not doing its best, and this is going to happen to a lot of people that are stuck in these visa backlogs right now if they're doing consular processing, The delays are terrible, but on the bright side, a lot of them are going to have green cards issued past the 2-year marks, meaning they'll automatically get a 10-year green card. So you gotta take the small wins that you can, and that's one of the wins that are coming there. Do you think the immigration bill has a chance in the Senate, or is reconciliation the best? Now, I've talked about this a lot on the show. I studied political science. I've been heavily involved in politics in my earlier days. What I realized, and this is like facts, you have no idea what's going to happen with this stuff, so it's not even worth pursuing. Unless you're one of the interest groups that is intricately involved in Washington, D.C., anyone else following this stuff is wasting their time. I wouldn't bother. Just when it happens, and that's about it. So I don't have any answers about this or even about court cases that are happening, that are pending. These judges, these politicians do whatever they want to do. So me following it, other than getting what the rule is at the end and see how it helps my clients, that's the most I could do. So I don't really get involved in the details of that kind of stuff. But along with this, to answer Supersede Kingsley Blinken, these lawsuits, when they come out, if there's going to be an impact, you'll hear about it. You'll definitely hear about it here. But so far, nothing's happening. One of the things that's happening with the delays historically has been a lot of cases in the Middle East in particular, after they do their embassy interview, these cases will get stuck in administrative processing, or AP for short. And sometimes these delays will be a week, a month, sometimes 6 months, sometimes years. And what has happened is immigration attorneys started suing the government for unnecessary delays, and it's been fairly successful to do this, to avoid these delays, by filing a lawsuit and saying it's taking too long. But recently there's been a couple of cases, especially in Washington, D.C. circuit, where the judge said, you know what, the government can take as long as they want. And so these lawsuits are going to come under fire. We'll see what happens. The administration is defending them. So just a quick heads up, there's going to be some changes with these lawsuits if you're interested in that kind of stuff. My I-130 has been actively reviewed by USCIS. I do not know how long it will take to be approved. Yeah, I don't either. It's just hopefully sooner rather than later. But it's all up to them and however long they want to take. So that's the problem with these timelines. You just gotta wait and see what happens. Lulu says, thank you for answering my question on TikTok. You're welcome. Thank you so much. I wish I had better answers. I don't like answering so flippantly like this. But I've just been doing this for a lot of years, over a decade. I'm heavy in the immigration game. I'm everywhere. I have a trade guide on this. I have videos. I've trained lawyers on this. I teach law school. These timeline situation is just never been seen before, what we're going through. So the only thing you can say is you be patient, and I don't mean to be offensive. It's just that's what it is. Where everything is inconsistent, so we don't have a way to give a proper answer. And people contact me for consultations, and I can make them feel good and say a shorter time, so they'll close the deal and come with me. But I just don't. I'm like, listen, you got to be planning your life. You want to maybe sell your house or maybe move here. I don't want you to jump the gun because the government is really inconsistent. Sometimes we get expedite requests done. I had one case where we didn't expedite request. The petitioner, U.S. person, unfortunately is getting sick in a way that's really bad, and they denied it at first. And then we kept fighting it, congressperson, redoing it, calling them, emailing them, faxing them, and just finally we got the I-130 approved after 2 months. So my heart goes out. I-130 is just approved now. It's consular processing, so we're still got to expedite the NVC step. We got to expedite the embassy, and so there's still a lot there. But it required a lot of fighting and a lot of bad information from my petitioner, who's got doctor's letters saying the sickness. And now I prefer, in my heart, like he wait longer to see his spouse and he wants to see her sooner, but not have a medical condition that's bad. But that's just life. It's a daily thing that we got to deal with. Immigration attorneys have turned into ER doctors almost, seeing this kind of stuff. Now, the I-130 process, there's different kinds of I-130. So this, I need to give you a heads up. When someone says I have an I-130, it could be a case for a parent, a brother or sister, adult child. You could be a green card holder filing for a spouse. You could be a green card holder filing, a U.S. citizen filing for a spouse. The child could be above 21, under 21. They're all different types of I-130. So you got to remember, when you ask a lawyer, how long is my I-130 going to take? Immediately it's like, well, what kind of I-130? And then we got to dig deeper. And then we got to know what country you're from. That's a whole different thing. So that's why a lot of these questions about time require an analysis that could take maybe 5-10 minutes at the very least to be able to bring it down. Even with that, we might not have an answer. That's why people always call me in my office and say, I have one quick question, how is this? The question might sound quick, but within that question there's 10 or 15 questions, and each of them have to be answered until we get down to business. And I try my best in these live, give you general ideas. but it's not something I can answer because there's not enough information. And at the end of the day, they're really inconsistent. A case that used to take maybe 6 months is taking a year now. So, and then all of a sudden it gets faster. Like I mentioned earlier in the show, citizenship cases were taking like a year. Some are taking 3 months now. Some are taking a year and a half. That's a wide variance. So if someone asks me in San Francisco, how long does my citizenship case, say, well, someone got it 3 months, some got a year and a half. How useful is that information? So the real answer is you just got to be patient, live your life, and don't worry about what's going on in immigration. Just wait for that all to happen. Hopefully you have an immigration attorney that's keeping an eye out for you to see what. Other than that, it's just using energy and brain power on something that it won't help you at all. So you just gotta be patient and live your life and do that. But thank you for the question. I understand where it's coming from. It's definitely, I'd want to know that answer too if I was you. But sometimes there are no answers or require a lot more information before we can get into it. I have a question. What is the maximum and minimum wait time for the process? I live in the States and we applied for 6 months now and still no fingerprints or employment card. There is no minimum and there is no maximum. That's just what I was talking about right now. It's all up to the government what they want to do. And so there's no minimum, no maximum. It's just a matter of being patient. My employment-based green card I-140 is approved and a fingerprint has been taken by USCIS. I'm waiting for my interview for adjustment of status at Form I-485. My question is, do I need to maintain my F1 status? Well, it's better that you do, but if you filed your Form I-485, you no longer need to maintain the underlying status. You're in a period of authorized stay until the I-485 is decided. You may not need an interview, probably will not have an interview, but the problem is you can't work. So maybe you're on your F1, you're on OPT or something like that. I'm not sure what part of F1 you are, but you do not want to violate your status by doing unauthorized employment. So you have to wait until you get your employment authorization document, EAD, work permit, all this kind of whatever name you want to use. But yeah, you don't have to maintain the underlying F1 status, though most lawyers would recommend it because there might be a glitch in your case. The employer might withdraw their case. Who knows what kind of crazy stuff could happen. And then you want to have something to fall back on. So it's my preference, you maintain the F1, but going to school, paying tuition, all this kind of stuff, it could be hard. So it's up to you. But generally, like the basic rule is, yeah, if you file for my 485 properly, and I don't know your case, I'm not sure if it's a good case or not. So if you don't have other violations or something, but if everything is perfect, let's say like that, which I don't know it is, then you don't need to maintain the underlying F1 status if you don't want to. You could just wait for a decision, but there's risk associated with that. Thank you for your question, Wes Belfort. We had a question from Amit. Do I need the NIE to travel on advanced parole? The NIE is a special exemption to the travel ban if you're visiting a country that's hit with a travel ban. Most of the travel bans have an exception for advanced parole, but it depends on what country you're going to. I haven't read the text of them, so I don't have I can't answer this properly without knowing what country you're going to and reading the proclamation, how it's read for the specific country you're going to be visiting. So I don't have an answer for you right now. It's something I have to look into. Eden asks, hi, just jumped in live, thank you. Any advice for divorce before I-751 removal conditions, evidence, decree after joint filing? We have children. I'm sorry to hear that divorce is happening. This is an issue I'm going to be working on in the public space, really hardcore in the next 6 months to try to just get rid of this stupid form. But the reality is you should consult with an immigration attorney. This is too case specific. You really need a proper analysis there. If you want to get a divorce, but we have to see what the timing of divorce is. There may be some waivers. There's a lot going on there that it wouldn't be appropriate for me to talk about here, Eden. But definitely, email my office, schedule a consultation. If you have children together, there's a good chance it's going to be approved anyway. But the timing of things becomes really significant in this horribly created petition called the I-751 removal of condition petition. But thank you for watching. Thank you for your question. Wes Belfort says, thank you, perfect, thank you as well. Can a citizen child 21 petition for parents with multiple EWIs, one deportation, time been served? It's going to be almost impossible because if you have multiple EWIs, potentially you're going to be subject to the permanent bar, then maybe a waiver, but it can't do that through a child. And then you have deportation, so that comes something that needs a proper waiver, but I'm not sure if we'll get it through you. Maybe, for example, your dad has these situations, but your mom doesn't. You would get the green card for your mom, and your mom would then act as a person for a waiver for your dad. But time's been served, that means there's criminal history from your sentence right there. I gotta know what the charge. So your question is just way too much analysis has to happen than I could answer here. Probably out of luck, to be honest, but there might be exceptions. I don't know. It's worth pursuing. It's your parents. why not? But definitely contact an attorney. I don't handle this kind of case, so I'd recommend consulting with someone else. But you have a rare chance of success, but it's your parents. You got to go search, you know, you want to have your parents here. But thank you for your question. Is smoking marijuana, can that be an issue? Yes. Marijuana possession, smoking, selling, this is all still against federal law. You know, federal regulations and immigration regulations come under that. Are all against marijuana. So there are small exceptions that they have in certain cases, but in general, there's a good chance your case can be denied or at least delayed significantly if they deem that you have, you know, marijuana use or drug abuse or something like that. So it's a very, very, very serious thing. Unless you're a citizen, you should not be touching marijuana. Even green card holders who are in the United States and living in California, Colorado, whatever many states that have legalized marijuana, it is illegal for them to do. Maybe it's illegal for a U.S. citizen to do too because it's against federal law, but you know, you'll deal with the criminal consequences. But if you're an immigrant that doesn't have their U.S. citizenship yet, even if you have a green card, if you smoke, not only are there criminal consequences, there's a good chance you get deported as well. So it's even harder. So definitely stay away from marijuana until they make this legal federally. But thank you for your question. How correct is USCIS processing times? I would say it's not correct at all, and don't rely on it. That's it. The way they break down this, the processing time says like there's two numbers. So they'll say, for example, an I-130 takes between 3 months and 19 months, some random number like that. The 3 months is, I think what they said was 50% of cases get done by the first number and 95% of cases get done by the second number. That's a real weird way to put something. Why not maybe, you know, add them all up, divide them, and get an average number? It might help out better, but who knows? And it's really hard because what you got to keep in mind, there's multiple different service centers, multiple different field offices, each processing things differently, different kinds of cases. Some have, you know, complex issues. I have cases where people's documents are really complicated. It takes them much, much longer to do. So at the end of the day, these processing times, the best an immigration attorney could tell you is based on their recent experience, which could be 100% wrong because things change. But just, you know, like I file a lot of marriage cases in Los Angeles, I have a good bearing on what's going on marriage cases in Los Angeles, or you know, maybe San Jose. I do a lot of Northern California cases, San Jose, San Francisco, sometimes Las Vegas. Those are where I do my most amount of cases. But you know, I have cases in New York, Florida, Seattle, Arizona. If my clients really want me to push me, I could contact local counsel that have friends everywhere and say what their average time is, but that could be wrong too. So I try not to focus on processing times, just say try to live your life as always. If I get a notice of intent denied, it says 30 days, will I get 60 days more? Right now, you'll get additional 60 days on a NOID, a notice of intent to deny on a case by USCIS because of COVID, so that's a plus right there. I live in the States, overstayed my visa, and now I'm married to a US citizen. I haven't been working the past till now. Is that going to be a problem? I just did my biometrics. Well, if you're married to a US citizen, the work itself is not a problem. That's typically, I mean, it depends on what work you're doing. If you're working at a gun range, that's a problem. But for general work, it's not a problem. But the issue is when you got the job, what paperwork did you use to get the job? Was it just getting paid cash at a restaurant? Okay. Or was it you know, signed up somewhere and filled out a form I-9 about your immigration status and you listed you're a US citizen? That's a major problem. So I would need more details about this to see is it going to be a problem or not. I can't answer that without going into exactly what your work history has been. But that's why you got to talk to the immigration attorney for pulling the trigger on this kind of stuff. You need to, and this is an important question. You should have asked this before filing. So you got to be cautious. It's your life, you know, but most likely you're okay, but you need to do stuff step by step. All right, everybody, thank you so much for joining us. We'll be back again next week, 5 p.m. Pacific time with more free consultation, education, talking about this stuff. And thank you all for joining. I really appreciate it. So many kind words coming each time. If you enjoyed this show, please go to my Google business page, JQK Law. Type that in Google and leave a 5-star review. You don't have to write anything, just 5 stars. We appreciate it. It helps me out a lot. But with that, I want to say thank you. God bless. Be safe. We'll see y'all next week. Bye-bye. I hope you enjoyed this educational video. We have a second channel with much more information as well at JQK Immigration Clips. Please check that out. Also, you'll find our social media site has a lot more videos, images, and information about the U.S. immigration process. Please check those out on the various social media websites.